Most people are familiar with a will. Most people have, probably grandma had a will, somebody had a will at some point in time. And a lot of times I think people think that that's all you need. And maybe it is. It really, every individual is different. It's going to be based on what type of assets and such that you have. But oftentimes, and this is just my opinion, if you ask 3 different attorneys their opinion on something, you're probably going to get 3 versions of a similar answer. But if you have real estate, if you have real property, a trust is a very, very important document. You cannot will a property your way. And I know most people think that you can, but let me ask you this. I mean, real estate transfers one way and one way only in this country. And how's that? It's by deed, right? By deed. You have to have a deed. And so if the house that you have is in your name and you die, you can't sign that deed, right? I mean, we agree. Gosh, yeah. Right? Yeah. So now we have this piece of property here with a deed that's in your name. And what do? Like, who has the authority to sell it? Who has the authority to sign a deed if you were to sell it? And the question is, I don't know. You kind of got to dig a little deeper, right? And so oftentimes people say, well, grandma left me her house in a will. And the truth of the matter is that will, as far as that house goes, is stating her intention. Her intention is for you to have it. But at the end of the day, we still have a deed sitting here. It's in grandma's name. Mm-hmm. And grandma can't sign it. Yeah. So how do you get it? Well, now you have to open up a probate. So you have to go probate the will, and at some point in time, go through some processes to have the authority for somebody to sign that deed.
Now, when you say probate, you're talking about like taking it to the court.
You have to file it in a circuit court. And basically, what you're doing, if you have a will, so let's just say that we have this will. You have a will. You're submitting this will to probate, meaning you're asking the court to recognize the will. And you have to have certain requirements. Like here, you have to have signatures of 2 disinterested parties. I go through processes and notarize. We go through the nth degree to make sure that something's never challenged. Mm-hmm. But it just really states their intention on how they want their property to be distributed. From a probate standpoint, though, when you open something like that up, I kind of say you're giving God and everybody an opportunity to file a claim. Right? Yeah. So when you open a probate up, it's a very public thing. If there's real estate involved, you've got to publish notice in the paper. So some people, some people don't know what a newspaper is, but now even like on legal ads online, you've seen it where it says like public notice, probate notice, something like that. That's what that is. It's somebody open up a probate and they're giving notice to the public at large that if you got a claim against the estate of this person, you've got a certain amount of time to file this claim in the court. Mm-hmm. And so that has to be done. And so
that all takes time.
It all takes time and money. That's the big thing. It takes time and money. So, here's the question too. So grandma has this house, right? And let's say she bought this house in, Jacksonville 5 years ago. She has a mortgage. So as somebody's going through this probate process, one, you're going to have to pay, right, an attorney to go file this probate and open it up. Right. This mortgage, taxes, and insurance keep on coming every month. Who's paying it? I mean, I don't know the answer. Yeah. A lot of times what I see, and I mean, quite frankly, I've purchased properties that got foreclosed on during a probate. Oh. Because what happens a lot of time is, get off another tangent. So, mom has a house here with a mortgage on it. I'm married and I have kids with a house, and brother and sister married and got their own mortgages. The average person doesn't have the ability to pay my mortgage and mom's, right? Yeah. So mom passes and we still have this mortgage. How do you preserve this property to move through the probate?
That's probably one of the most common situations.
Happens all the time, every day. And it's so unfortunate because a lot of times you'll find properties that actually, had some equity in them that by the time they go in default, go through the foreclosure process, they get sold off and there's nothing, right? And so it's very unfortunate. So that's where a trust can come in. Mm-hmm. So basically what you can do in a trust, and I'm kind of give an overview because it's a little more complicated than this, but kind of think of a trust like a holding company. And so you can set up a will and put everything that you have into this trust. And so if I have my house, like my personal house is held in a trust, I've actually deeded it over to the trust. Now, my wife and I are the trustees of our trust, but I don't own that house anymore, technically.
Gotcha.
Right?
Yeah.
And so the beautiful thing about a trust is if I said, okay, if something happens to my wife and I want Yahshua to be the trustee, right? And within that trust, I dictate what's going to happen. Like I want the house sold and the proceeds to go to my children or whatever. You stand in my shoes on the day that I pass. You stand in my shoes as the trustee. And you have the legal authority as the trustee, because I've given it to you, to hire an edge agent, right? List the house, put it up for sale, go to the closing and sign the deed. We don't have to go to a court. I don't have to go to a probate.
Yeah.
Because you have the authority as the trustee to sign as the trustee of my trust on that deed.
Yeah.